All right, we are live. Good morning, my fellow Michiganders. Good morning, my fellow Americans. We are extremely excited again to have the Attorney David Kallman on because we know there has been an astronomical number of questions out there, a lot of confusion. So we're going to get right after it today, and I'm going to go ahead and let Ron lead us with some conversation.
Hey there, everybody. We had a great Saturday about 10 days ago. When we had this first Supreme Court ruling. There's been so much that's happened since then. We're getting so many questions from so many of you as to what these other rulings have happened and what these new healthcare orders and health department orders and MIOSHA. And so we thought the best thing to do is go to the expert. And David Kallman is the expert. He's there to assist us along the way. We chat regularly and trying to give you the best information we can, but there's no better than to come directly from him. So David, I just want to welcome you for, again, being with us today.
Ron, it's always a pleasure. Glad to be with you.
So let's start out by the great news that we got after the first ruling by the Supreme Court. She had answered that and requested some clarification, whatever. And we had this 21, which the request was 28 days, that she wanted to continue what they called her powers. Can we just clarify what all happened in those latest rulings? Because it's so important for our people to understand the win that we got for the rule of law.
Sure. Well, as everybody knows, the governor came right out after the Supreme Court ruled and claimed that she had 21 days to still enforce her executive orders. We, right from the get-go, said we did not agree with that. We didn't think that's what the law allowed, that this was a certified question case from the federal court. It was not a typical appellate case that had come up through our lower courts. And so the 21 days and the court rules they were citing did not apply. Well, the Supreme Court ruled the end of last week, issued an order agreeing with us again and saying, yes, that's correct. There is no 21-day stay of their order, that it took effect immediately, and it denied the governor's request for that 28-day extension to keep it open. And I found that interesting too. I mean, why did the governor file a motion requesting the court to keep it open for 28 days so that she could still enforce the orders if she thought there was an automatic stay that she had 21 days? I mean, those two things did not make sense. But in any event, the Supreme Court knocked down both those arguments and made it crystal clear their ruling was immediately effective when they issued it a couple of weeks ago. Now, there was a second order that got issued the same day that I think is kind of getting lost in the shuffle here, and that was on the companion case that the legislature had filed. The legislature had filed a case making all the same arguments, delegation of authority, delegation, separation of powers, all these same issues. And the Supreme Court issued an order in that case, separate from the federal case. And they said, we are preemptorily reversing the Court of Appeals and adopting the same rulings that they made in the federal case, and ruled our way and ruled the legislature's way, 100%, again, throwing out the 1945 law and saying it was of no effect. And then so it was clear that there was no confusion here. The Supreme Court said, and that order on the legislature's case took immediate effect. So again, none of this 21-day stuff. I just found it interesting, the argument, well, we had 21 days. I mean, imagine that the police had been using a search and seizure process when you got stopped in your car. And the Supreme Court said, no, that's an illegal process. You cannot search somebody's car the way you were doing it. Do you really think the police would come out and say, oh, we have 21 days to keep violating everybody's constitutional rights and to do illegal searches and seizures, even though the Supreme Court has ruled? You see how silly that is. It's just a silly argument. So thankfully, our Supreme Court in both orders last week knocked down not only that argument that the governor's office was making, but also affirmed in the legislature's case that they win too. And that was a big, for all the reasons that they set out in the federal case. So both those orders were very, very important and are great orders.
I guess what I believe, like you do, that she was aware she didn't have 21 or 28 days. That was a way to hold everybody in the positions they were in. Don't be free. Don't go out and act like you've won, because we're going to find another avenue to be able to come down.
Mm-hmm.
And we saw that only a couple of days later. Obviously, this ruling I thought was great because it went to 6-1. Two of the people I think were pretty fed up with her attempt to utilize their opinion and continue with her own demands and orders. And I think that that was a slapdown if you ever saw one, going to 6-1 that way that was written. But obviously she doesn't stop there. But I do want you to clarify before we go into the health department and the MIOSHA things that have followed is how different things still have to be gone forward. I don't want people to believe that these have the teeth that they had when she had an executive order, when she had an emergency law to operate off of. That was a totally different situation than what can happen with the MIOSHA or health department rules and regulations, as we call them, going forward. Am I correct?
Yeah, so I've noticed that, of course, we've been getting a lot of contacts from people and questions about what's been going on over the last couple of weeks. And I see a real sense from a number of people that, well, what's the point? We won in the Supreme Court and they're just going to do all the same things all over again now through these other orders. And so it'll never end. What's the point? Well, I think that's showing a misunderstanding of what's occurred. I mean, obviously, MDHHS, our health department in Michigan, and MIOSHA, that regulates businesses for safety and things like that, they have separate authority under their statutes and their rules to issue limited orders dealing with the areas that they have purview over. And so the idea that all the things that the governor did through executive orders are now just being implemented in these agency orders is simply not true. For example, MIOSHA can only regulate businesses and employees. That's it. They can't regulate customers coming into the business. They can't regulate you in your private life. It's a very limited, narrow scope of what authority they have. It's only over businesses. Now, that's a big area, but you see how that's much more narrow than what the governor was doing with her executive orders. For example, MIOSHA cannot order a shutdown and order everybody to stay at home like the governor tried to do and did do. MIOSHA can't order that. Director Gordon through the health department cannot order that. So that's huge. I mean, there's lots of other things that were put in place through orders, all kinds of regulations, unemployment, I mean, all kinds of things that the governor was doing. I mean, she issued over 180 orders, okay? So understand that. That's a lot of orders. Most of those things she cannot do through these agencies. So people should be encouraged that it was a major win. And even though maybe there's 20% or 15% of things where they're trying to re-implement things and regulate people through gatherings and that sort of thing, which we'll get into, it's not as all-encompassing as what the governor was doing. Her orders are no more. They're invalid. They're unconstitutional. And many of the same issues that were raised against her orders can also be raised against these Department of Health orders and the MIOSHA orders. And of course, it will take another round of litigation. Of course it will. And of course they're going to try to enforce it. But that doesn't mean that everything the governor did is now back in place. Far from it. I would say the vast majority of what she did is not in place. So people should be encouraged by that.
That is terrific. Now, Garrett, you're able to see lots of comments there. I know we're going to want to get into the health department orders that started and now the latest with this 9-page MIOSHA. But do you have something from people out there that you've seen, Garrett, at all that are direct you got?
Oh, yeah. They're coming in fast. Just a couple of them right off the bat, and especially in my field as a chiropractor, a healthcare professional, we have a lot of patients, who cannot wear the mask. We have autistic patients. We have, unfortunately, a lot of women who have been sexually assaulted. They can't have any face coverings. And the question out there is, can health providers deny somebody service if they can't wear a mask?
Yeah, that's a great question. And in fact, based on Director Gordon's order, the answer to that is clear. No, they can't. I mean, now if a medical office or doctors do that, they're opening themselves up to huge liability and medical malpractice and all kinds of things. I mean, I hope they have good lawyers is all I can say, because even Director Gordon's order makes it clear that if you have a medical situation that you cannot tolerate wearing a face covering, and that is through your own assertion, all you have to do is say that that's your position, that you can't do it, that you are exempted from the mask order. I mean, even right now, that's an exemption in Director Gordon's order. So if there's somebody out there that's being denied service, they need to get some legal help and have a letter sent to that doctor's office or that hospital or whatever, and tell them you might want to take a second look at the order here and stop denying service, because if I get harmed or whatever, they're liable for damages for something like that. So it just shows the confusion that's out there in the general public and in the healthcare community as to what is or isn't required. Now, having said that, remember, private businesses, private doctors, okay, that are not part of the government can have whatever requirements they want in place to have in place. I mean, they can make their own requirements. And that's a different issue. I mean, this whole argument that I've heard about private businesses are an arm of the state, you know, and that if a business like Lowe's or your local chiropractor says, I don't care if there's an order from the state or anything else, I want a mask worn if you're in my business because that's what I want to do. Well, they're doing that because that's their choice, okay? Not because of anything that the state's requiring them to do or anything else. And so can a business do that? Yes. And is that a violation of your constitutional rights? No, it's not. I mean, constitutional rights, the limitations are against government, not against private individuals. And we cite that. If people want to go to our website, greatlakesjc.org, we have an issue brief and we have a FAQ that we put up in the last week or so, outlining all this in a lot more detail. But it is crystal clear that private individuals, private businesses are not an arm of the state because they might have a mask requirement or something like that. Now, could there be other things that that private business might be violating, like the ADA, you know, Americans with Disabilities Act, or other laws, discrimination laws, things like that? Those are all possible causes of action. But people need to understand the difference. I mean, you can't sit there and say, my constitutional rights are being denied here. No, they aren't. Not by a private business, they're not. Now, again, there can be exceptions. There are private businesses that contract with the government to provide services, like protective services cases and agencies and things like that. So would they be an arm of the government? Yes, because they have a contract or an agreement and they're acting on behalf of the state. But those are very narrow. I mean, when we're talking about these issues of masks and social distancing and things like that, there's no contract between Lowe's and the government, you know, to do anything. So, you know, understand the difference. There's a big difference between your constitutional rights being violated versus some statutory violation like the ADA or the Elliott Larson Act or something like that. Big difference.
So another question that came up for previous fines, like the people who got fined with giving the haircut on the lawn of the state capitol, you know, everybody that's got fined from violating these orders, what do they do? Are they still have to pay those fines?
They shouldn't. I mean, if somebody does, that's up to them, I suppose. But we have a number of cases all around the state and representing folks from Carl Mankey to the Frisky Orchards up in Charlevoix to, you know, lots of gym owners around the state. And we're in the process right now of getting all those cases dismissed because they were based on the executive orders. So I don't anticipate any of our clients paying a dime for fines or anything like that. And if a court tries to impose that or whatever, we'll be appealing that. That'll go up to the Supreme Court. That'll never hold up. No way. You cannot be required to pay a fine or have a penalty imposed for an unlawful, unconstitutional order. It's that simple.
You know, that's one thing that I wanted to clarify, and I've got a question here that was actually made in our comments before we started. But the one question is, again, is the enforcement capabilities of this, the fining opportunities or obligations that they're listing in here through both of these health department and MIOSHA. Are those, do you believe, valid that they are able to fine individuals based on these rules? Or do you believe that those fines, that they don't have that capacity within their jurisdiction is my question.
Well, again, we answer that in the issue briefs and the FAQ and at our website, again, greatlakesjc.org. But to give you a quick answer, let's use Director Gordon's order, for example. He does have authority under the Public Health Code to do two things, all right? Again, this shows how limiting this is. He doesn't have broad, all-encompassing power to order everybody in the state of Michigan to do whatever, okay? Here's what the law says he can do. Number one, he can, if he believes there's an epidemic still in place, so that's a first threshold, that there's an emergency, he can issue an emergency order to prohibit gatherings for any purpose. That's number one. So what does that mean? Prohibit gatherings for any purpose. This law has never been tested in our state history, as long as it's been in place, like 50 some years, because it's never been used. Or I think it was maybe used by Governor Snyder briefly in the Flint water thing, but it was much more narrow in scope. So it's never been challenged. So what does the word prohibit mean? I think the word prohibit is pretty clear. It means to ban something, to stop it from happening, right? So you can see the problem. Director Gordon's order limits gatherings and puts them into smaller numbers and things like that. Is that an outright ban? I don't know. There's an argument you could say that the lesser is included in the larger. You know, a limit is a part of a prohibition. But there's another argument to say, no, it's very specific. The statute says prohibit. And then it says for any purpose. What does that mean? So that gets into just one issue of gatherings. And what is a gathering? Nobody knows. I mean, if you get together and you're at a restaurant, are you at a gathering or are you at a restaurant where your family's sitting down to have a meal? You didn't go there to gather for any purpose with anybody else. You're there to get a meal. So you see all the problems that can arise, and nobody knows what all of this means. But that's number one. And he's issued this order where he's trying to limit gatherings and then adding all this other stuff with face coverings, the mask situation, social distancing, can't sell concessions at sporting events, the contact tracing stuff. There's all kinds of things in there that go way beyond that grant of power, whatever it is, to prohibit gatherings. The second thing that the statute says is that if he finds there's an epidemic, he can pass procedures to ensure the continuation of public health services and the compliance with the public health laws of our state. Well, there are no public health laws in our state dealing with masks, all these things that we're talking about, okay? So that's not an issue. So the issue is what procedures can he put in place to ensure the continuation of essential public health services? Well, nobody knows. What does that mean? But there's a big difference between providing services to the public, like free flu shots. Here's information at our website. If you have somebody ingest poison, here's what you do. Making sure hospitals have everything they need for helping the public in a health and safety situation. All those sorts of things are ensuring services. What does that got to do with mandating and ordering people to do something? It has nothing to do with that. He has no authority to order those things under that. But yet that's what they're trying to do. And let me give a real clear example on the masks or the face coverings, as they call it in the order. It would be a public health service if the department handed out free masks to people. Anybody that wanted one, come get your free mask. That's a service, right? How is it a service to say you must wear a mask? That's not a service. That's an order. That's telling you to do something. And what does that have to do with prohibiting gatherings? Nothing. So kind of a long explanation there, but just to let people know, these things have never been tested, and that's why there will be another round of litigation over this as to how far Director Gordon can go with all of this. And nobody knows. But back to your first part of that question, Ron, will the government try to enforce it? Will the governor and the AG come in and prosecute people, impose fines? Of course they will. They're going to do it just like they did with the executive orders. And since last May 1st, we've been arguing they had no authority. And we filed lawsuits all over the place, starting with our federal lawsuit for churches and all of that, which we won back in May. And all those things, until a court rules, they're going to try to do what they can do. They're going to try to enforce it. Doesn't make it right, but that's what they're going to try to do. So that's why we tell people to count the cost, look at their situation, and decide, are you going to fight it, or are you going to wait for others to fight it and see what happens?
And just to let the people know, it's exactly what you just said, David. You guys won with Carl 7-0 when she was still operating under that law. So people just need to stand up and fight this, and the odds are they're going to win in court.
Right. And remember that church case. People forget about that. We filed in federal court within days after the expiration of her joint approval from the legislature. It ended April 30th this year. We filed a lawsuit just a few days later in federal court because they were prohibiting churches and mosques and synagogues from meeting. And the next day, the governor changed her executive order and allowed them to meet. And in fact, if you look at Director Gordon's order, he has a clear exemption for churches, synagogues, places of worship, that they can meet and engage in worship and not wear masks, not have these requirements in place. That's a clear part of this order. So people need to really read the order. We may not like everything they're doing, but there are parts of it that are not as severe as what Governor Whitmer was doing. And, people just need to see what's there.
The media and the governor and her administration would like us to stay and remain in fear. That's where we're really at. Meaning, if we can get you all convinced that this is the best thing and you need to follow these regulations and there will be stiff penalties if you don't, that's what we've been saying from the beginning is we do need to stand up. And if together we come up and say we've had enough, the Supreme Court's ruled, the legislature hasn't worked with you on real laws going forward. And until then, we're going to live our lives as clean as we can. Yes, there are going to be challenges, but if we all stood up together, there would be no ability for enforcement because they have no idea where to start. Am I right?
Absolutely. That is absolutely true. And in fact, the Supreme Court in their orders last week made it clear, they directly said to the governor, you should work with the legislature and come up with a reasonable plan that everybody can agree on, or at least that most people can agree on, in order to deal with this situation. Look, again, the COVID virus is a serious thing. Nobody's saying it's not, that people are dying from it. There are problems with this. But this nanny state, government knows all and must tell you what you have to do, and people can't use their own common sense and use their own adult decision-making powers to decide what's best for you is ridiculous. I mean, we don't trample our system of government and throw out our separation of powers in our constitutional republic because we have an epidemic or because we have a virus running around. That's ludicrous. That sets the stage then for a dictator or somebody come in later with some other issue, make up something. And what's an emergency? Now we take over. That's ridiculous. People need to understand you cannot give up our constitutional rights and freedoms because of fear from a virus. Use common sense. I mean, if you're 70 years old and have underlying problems, it's probably not a good idea to go meet at a big event or to, maybe you would wear a mask when you go to Myers or things like that. I mean, you can make common sense decisions for yourself. That's all this is about. We don't need the government mandating this stuff.
You're exactly right. Especially we tend to be in our own bubble in the state of Michigan. And a lot of people don't realize there are other states that are basically free in doing exactly what you just said. If you're unhealthy, quarantine yourself, but you don't quarantine the healthy people. It's common sense.
Yeah, absolutely. It's common sense. And it just, it kind of, you look at everything that's going on with this right now and the whole controversy. The CDC or the WHO, the World Health Organization, just came out and said lockdowns really aren't effective. We shouldn't have been doing this. Well, guess what? We've basically destroyed our economy. Now it's coming back for something they're now saying, oh, oops, I guess we shouldn't have done it. Are you kidding me? And then we're supposed to sit here and just say, oh, if you don't wear a mask, you're killing grandma. And we're just supposed to accept that. And now we're hearing all this stuff that people who back in July and August got the virus, 85% of them were wearing their masks either all the time or most of the time. And they still got the virus. I mean, folks, we need to understand that we're being sold something here that is not accurate. And the person from the WHO, the doctor there that's in charge of all this, came out this past just in the last few days and saying that now world poverty has doubled. Poverty in the world has doubled. Deaths from lack of treatment because of cancer, depression, and other things is skyrocketing. You know, do you hear anybody talking about a study or looking into, well, how many collateral deaths have been happening and how many, and weigh those two things? Okay, we have deaths from the virus, but we have all these other deaths going on. Which is worse? And our economy being harmed and destroyed, restaurants going out of business. On and on. I mean, look, folks, life has risk. Okay, we got to decide what kind of risk are we willing to accept, and not let government just destroy our economy and our way of life and our form of government. That's what this comes down to. Stop being afraid. Make common sense decisions for yourself. Protect yourself and your family. Do what you think is best. But let's keep moving ahead.
I think it's we've been saying the same thing, but it is great to hear it from somebody with your knowledge and authority and experience, and I know you're hearing it from so many people. I had one again that had been sent through comments, a question, and this was an interesting one. He said, as a business owner, I've had some question and concerns. I did notice that an email and the link takes me to the emergency rules and not orders. Do rules carry the same weight as orders or laws? We operate a small theater. We have a rule that you shouldn't use a cell phone. And if you break the rule, we ask you to leave. If you, on the other hand, use a cell phone to record a movie, you're breaking a law. My question is, under these rules, do we have more lateral ability and not quite the enforcement action as you do under the old executive orders?
Well, see, there's a big difference. That would be a whole other topic probably. But there are differing ways that agencies can act. They have what are called administrative rules. They have things that are called guidelines. They have procedures. They have interpretive statements. They have a whole laundry list of ways that they can put out edicts or how they're going to function as an agency. What's binding on individuals are rules. Procedures, interpretive statements, guidelines, all those sorts of things are not binding on the general public. What happens is agencies will a lot of times take a guideline or an interpretive statement and then try to enforce it as if it's the law. I have litigated that issue with various agencies in the state for almost 40 years now. As one area, I can honestly say I've never lost a case, ever, because the law is so clear. The agency has no authority to enforce these guidelines and interpretive statements. Now, rules, yes, they can. And what they're doing now is there is a process for emergency rules that can be in place for 6 months. That's what MIOSHA did yesterday. They issued a bunch of emergency rules that are now, they will be enforcing, and there are enforcement capabilities. We're looking at that. They just came out late yesterday afternoon. I think you're still going to, it appears to me they go too far and they go beyond MIOSHA's authority. But do they have authority to issue emergency rules? Yes, they do. And what can they do with that? We're going to be analyzing that, and we'll be putting out some information on that in the coming days. So again, you can go to our website and greatlakesjc.org and keep an eye out for that sort of thing. But that's a great question, because there is a big difference between an administrative rule, which has the force of law, and other types of actions that agencies do that do not have the force of law.
What you've been clear on, and you'll read it as you guys go there. If you go to Great Lakes
JC.org. Yeah, Great Lakes Justice Center. Yeah.
There are some terrific, that fact sheet you put out in that is some great question and answers. I'd encourage everybody to go there and look at that. The one thing that you had mentioned in there specifically when I read was, again, this requirement of certain distancing, or this requirement for face coverings within these facilities. We don't believe that there really is any authority of those things within their prerogative. Am I correct?
Right. I don't think that falls under the prohibition of gatherings. But again, it's going to be up to a court to rule on that. That's our opinion. I think we've been fairly successful so far over the last 6 months as we've litigated these issues. People are free to choose who they believe, or what advice they take on this sort of thing. But I would agree with you, Ron, that is something that goes beyond the director's purview. And again, with these MIOSHA rules that just came out, the emergency rules yesterday, understand those only apply to businesses and their employees. It doesn't apply to customers coming to the business. It doesn't apply to anybody else. It's just businesses, and it's for safety issues. Okay. So we'll be, like I say, we'll be looking at that and issuing hopefully some helpful information on that in the coming days.
So what you're saying, Dave, is that our individual lives are free. Individually, a lot of these things do not have the authority over us, MIOSHA or health department, other than this so-called gathering thing. Individual in our families and what we do there, they have no authority over any of those things, and that is freedom, right?
Absolutely. Or to go to church or to your synagogue or wherever, your mosque. I mean, all these things, and there's so many other areas. Like I say, there were over 180 orders. The vast majority of those are gone and not enforceable. They've been found to be unlawful, and they're not being reinstituted through Director Gordon's orders or through these MIOSHA rules. Those are much more narrow. So people, again, people need to be celebrate, what our Supreme Court did and the freedoms that we have gotten back, and our form of government and separation of powers and all those things have been upheld. Let's not forget that. Does that mean the whole battle is over? Of course not. And we're seeing that. The governor and the attorney general and others I can guarantee you, they will be prosecuting people for violating these orders or rules that they're putting in place. And then that's just going to be another round of litigation.
One more thing, Garrett, I'm sure you got a couple more questions, but I want to, before I forget, the need to repeal the 45 law. For those of you that saw the hearings that were held in the House where they were questioning Senator Barrett, if you recall that the Democrats that were questioning him literally were saying, yes, it was deemed unconstitutional, but isn't it true that we could modify the law and clarify the unconstitutional law and leave it in place? That is actually the thought process for them. And I want to make sure you comment on the importance, because a lot of people are jumping to, well, what's the bother now? They've considered it unconstitutional. We don't need to worry about that law any longer. And I'm saying, be very careful.
Absolutely. That's why it's still important for the Secretary of State to do her job, certify those signatures, and then get it in front of the legislature to repeal the law. Because, see, the court's ruling did not repeal the law. Understand the difference. That 1945 law is still on the books. It's there. It's just our Supreme Court has said it's unconstitutional. Now, I think the Democrat argument that, well, we can fine-tune it or change it a little bit is ridiculous, because the Supreme Court said it's unconstitutional in its entirety. They said the whole law, okay? But my concern would be, if we don't win in this election here in a couple weeks and get someone like Brock Swartzel on the bench, and I can't endorse him enough for Supreme Court. He was the judge who ruled our way with the Court of Appeals on Carl Mankey's case. We lost 2-1 in the Court of Appeals on Carl's case. Brock Swartzel was the judge who ruled our way, and it gave us the springboard to get to the Supreme Court and get a 7-0 decision. So Judge Swartzel is imperative to get on the Supreme Court. We have to get him on there to maintain this balance right now of at least a 4-3 split on our Supreme Court. Because if that goes to a liberal judge who doesn't believe in following the law, they could come back next year with a new case and overturn what the Supreme Court just did. I mean, they could reinstitute the law because it's still on the books. So it's very important that Unlock Michigan's petition drive be carried through, and that law be stricken from our books, that it be repealed. That's very critical. Yeah.
Yeah, and I don't care if it wasn't, because I'd still just want it through from all the hard work from we the people.
Yeah,
so
absolutely.
We want to see it done just to feel good about ourselves. But there's a couple questions, and we talked about this before, David, with schools and being in the workplace. And so a lot of people keep asking the same question, like, if they have a medical exemption, are they still required that they have to wear a mask at school?
Well, once again, if you cannot tolerate the wearing of a mask under the current order from Director Gordon, you're allowed to not wear the mask. Okay. Now, does that mean a private business or a school or whatever might not still require it? Like I said, that's their call. And I don't think that's a very wise decision, because it could, or you get denied entry, like you were saying, to get medical services or things like that, that could expose them to liability. But that's the whole point of freedom too. I mean, if a private business just says, we're scared to death, we're living in fear, we don't care, everybody will wear a mask at our store or you're not allowed in. Well, they can do that. And then what do you have? You have the freedom to go somewhere else to shop. And if there aren't a lot of other stores, you'll do it online, find other ways, start co-ops, start your own things to get your produce and to get what you need to do. That's what freedom's all about. And once those businesses start losing business because people stop showing up, guess what? Their policy is going to change. I mean, that's the way our system works.
Thank you, David. Ron, do you have any other questions?
No, I think this was incredible. All I'd ask, David, is I'm sure with the ever-changing things that'll happen over these next couple of weeks is see if you'd be willing to come back on again within a couple of weeks and keep us all updated, because we take your information, we're reading your site and trying to reiterate that to our people, but they're running into their own individual situations. We can't answer all of them. We are leading them to your website, and we just would ask you to come back and keep us all informed.
Glad to do it anytime, Ron. Garrett, we're glad to be with you. Appreciate your work. And let me just again remind people, don't forget the nonpartisan ballot in a couple of weeks. Vote for Judge Swartzel for Michigan Supreme Court. It's critical. And in your areas, know who your local judges are and who's running, and find out who are the ones that are strict construction originalists that will follow the law and not make it up. Vote for judges like that. It's critical. But Judge Swartzel, we got to get him on the bench.
Wonderful. Thank you so much for your time, David. And out there, just like what he said, we have to stand up, folks. That's what you have to do. You have to stand up. This is going to be battled in the court, so don't depend on everybody else to do this. You have to start standing up for your rights, and you have to fight. So God bless you, God bless the state of Michigan, and God bless these United States. We'll talk to you all soon.
All right.